Welcome back. In the last session, we have discussed about TRIPS in general. In this particular session, we are going to discuss about the Indian obligations under TRIPS, because it is very important to know what is the relevant condition in India, because in the last discussion we saw, like, though there is some general agreement, but how the execution takes place, it depends on the member countries and their rules and regulations with their respective legal system. So, here in this module we are going to discuss about the conditions with relevance to India. So, again the outline of this module will focus on impact of TRIPS on relevant Indian legislation. Is there any special or unique provision on patents in the Indian law? Under what conditions is a trademark granted in India? How is an industrial design defined in India? The IPR of design is covered by the Design Act 2000. Important aspects in Indian Design Act 2000. Protection of copyrights in India, and challenges in negotiations on various IPRs under TRIPS in India. Now, we will start our discussion one by one. Now, what is the impact of TRIPS on relevant Indian legislation? Here we find, in order to meet the requirements and comply with the international obligations, a number of domestic IPR laws were amended. The Indian Patent Act 1970 was amended to conform to the requirements of TRIPS. The first amendment to the Patent Act 1970 was effected through the Patents Amendment Act 1999 that was brought into force retrospectively from 1st January 1995. It allowed for filing of patents in the areas of drugs, pharmaceuticals and agrochemicals, even though such patents were not allowed. So, originally these patents were not allowed, but after the amendments these patents were allowed, keeping in line to with the TRIPS agreement. The second amendment to the Act 1970 Act was made through the Patents Amendment Act of 2002. New patent rules were introduced, which came into force on May 2003, and the earlier patent rules passed in 1972 was replaced by it. With these amendments, India met all its obligations relating to patent protection that it was required to meet by the year 2000 under the TRIPS agreement. It also brought the Patents Act in conformity with the requirements of the Patent Cooperation Treaty of WIPO as modified until 2001. So, how it got aligned with the TRIPS agreement and with the Patent Cooperation Treaty of WIPO gradually by two different amendments. Again, there was a third amendment to the Patents Act in 1970 was initiated through the Patents Amendment Ordinance 2004 with effect from 1st January 2005. This ordinance was later replaced by the Patents Amendment Act 2005, Act 15 of 2005 on 4th April 2005, which was brought into force from 1st January 2005. So, what this gives? This amendment provides access to India to start providing patents for drugs and medicines foods and chemical products. This final amendment brought India in full compliance with the TRIPS and its obligations. So, what we see for India, initially the patents for plants and some foods and medicines were not allowed, but because TRIPS provided it, slowly by step with amendment, it brought in these provisions. This amendment provides access to India to start providing patents for drugs and medicines, foods and chemical products. This final amendment brought India in full compliance with its TRIPS obligation. So, what we see through this process, India got slowly aligned with the TRIPS requirement through 3 different amendments. Initially, the patents for some medicines, for some foods and plants were not allowed, but then gradually to get aligned with TRIPS requirement, these provisions were brought in through the different amendments, and finally after the 3rd amendment it got totally aligned with the TRIPS obligations. Similarly, in the case of trademarks, the governing law in India now is Trademarks Act 1999, and this was brought into force with effect from September 15, 2003 to bring it in compliance with TRIPS by repealing the Trade and Merchandise Marks Act in 1958. The Copyright Act 1957 today is compliant with the most international convention and treaties in the fields of copyrights. India is a member of the Berne Convention of 1986 as modified in Paris in 1971, the Universal Copyright Convention of 1951 and TRIPS. Though India is not a member of the Rome Convention of 1961, the Copyright Act 1957 is fully compliant with the provisions of these conventions. In subsequent discussions, we will have details about these conventions and what are these all about. And in the last discussion, if you remember, we have discussed about if the members from other countries are coming, then they are treated as natural and legal entities and based on the eligibility criteria of IPR as discussed under different conventions like Rome Conventions and Berne Conventions, and this we will discuss in details about these conventions in subsequent discussions. Two new treaties, collectively termed as Internet Treaties, were negotiated in 1996 under the auspices of the World Intellectual Property Organization. These treaties are WIPO Copyrights Treaty, WCT, and the WIPO Performances and Phonograms Treaty, WPPT. These treaties were negotiated essentially to provide for protection of the rights of copyright holders, performers and producers of phonograms in the internet and digital era. India is not a member of these treaties. Now we are going to discuss about the Indian specific situation. Is there any special or unique provision on patents in the Indian law? What we see, Patent Act has a set of exceptions mentioned in section 3 by which certain things cannot be protected by the law. One unique provision is clause D mentioned in the section 3. This provision prevents patenting of minor improvements in chemical and pharmaceutical entities unless the invention results in the enhancement of known efficacy of that substance. So, this is a very important step so that research can progress. If we are going to patent each and every step of how, like the improvements, and more so in case of chemical and pharmaceutical entities, and you are not going to share this information with others based on, like you will tell it is an intellectual property, then knowledge sharing cannot happen. We cannot progress, and others cannot start their research or experimentation, like how to improve on that. So, to safeguard for that, this is a very, very important provision which tells these provision prevents patenting of minor improvements in chemical and pharmaceutical entities unless the invention results in the enhancement of known efficacy of that substance. These prevents patenting of mere discovery of any new property or new use for a known substance, or of the mere use of a known process, machine or apparatus. These provision, as I have already discussed, is a safeguard for health, public health purposes, and sets a higher threshold which has been interpreted as therapeutic efficacy for the grant of a patent on pharmaceuticals. So, it is very, very important aspect from the angle of public health, because if you are going to safeguard every part of your knowledge, and if you are not going to share with others, if you are going to restrict others on experimenting on it, then public health in general may suffer. So, to protect for that, to safeguard for public health, this is a very, very important provision given. We will discuss who provides patents in India. In India, the Controller General of Patents, Designs and Trademarks is responsible for the administration of Patents Act 1970 through the patent offices located at Kolkata, Mumbai, Delhi and Chennai. So, the Controller General of Patents, through these 4 nodal locations, are responsible for the administration of the Patents Act 1970. Next, we will discuss under what conditions is a trademark granted in India. Under the Indian Trademarks Act of 1999, the following conditions have been included for the grant of a trademark. Definition of a trademark has been enlarged to include shape of goods, packaging and combination of colors which can be adopted as a trademark. Registration of service marks allowed in addition to trademarks for goods. Single registration of trademarks. No separate application is necessary for each category or class of goods or services. A single application would do. So, we understand, so there is less hassle of paperwork or providing relevant documents. However, filing fee will be charged separately for each class of goods or services. So, next we are going to see, like, there is an enhanced punishment for the offences relating to trademark on par with the Copyright Act 1957 to prevent the sale of spurious goods. Terms of registration of trademark is 10 years, subject to renewal thereafter. Registration of collective marks owned by associations is allowed. Some offences relating to trademark made cognizable. Extension of application of convention countries in India. So, it is very important, like when trademark it gets copied or offences are happening. So, there is a punishment, relevant punishment for that also, and this helps in stopping the sale of spurious goods. Next, we will discuss about how an industrial design is defined in India. The IPR of design is covered by the Designs Act 2000. This means only the features of shape, configuration, pattern, ornament or composition of lines and colors applied to any article, whether in two-dimensional or three-dimensional or in both forms, by any industrial processor means whether manual, mechanical or chemical, separate or combined, which is in the finished article, appealed to and judged solely by the eye, but does not include any mode or principle of construction or anything which is in substance a mere mechanical device, and does not include any trademark as defined in the clause 5 of subsection 1 of section 2 of the Trade and Merchandise Marks Act 1958, or property mark as defined in section 479 of the Indian Penal Code, or any artistic work as defined in clause C of section 2 of the Copyright Act 1957 43 of 1958. So, what we find, it gives an extensive coverage of what is design, and we find like it is a form of any shape, configuration, pattern, ornament, composition, lines applied to any article, whether two-dimensional, three-dimensional or in both forms, and which can be produced either manually or mechanically or chemical or separate, or it is combined, and in the finished article, and it is judged solely by the eye, but does not include any mode or principle of construction, and does not include any trademark as defined in the clause. So, it is something which is got included, and there are certain things which are not included as mentioned in the details. So, identification of non-registerable designs, introducing a classification system, elimination of secrecy period of 2 years for a registered design, provision of public inspection after notification, introduction of rights of registered proprietor of design. So, if you have a design which is of aesthetic nature, so you can go for the protection of this under the Designs Act 2000. So, the initial term of protection is for 10 years, which is followed by another 5 years on request, and provision of restoration of the lapsed design, so that it becomes like artistic, because it has its artistic value, so it can be referred to. So, provision for the restoration of that lapsed design is also there. Next, we will go for discussion of the protection of copyrights in India. The Indian Copyright Act 1957 protects original, literary, dramatic, musical and artistic works and cinematograph films and sound recordings from unauthorized uses. Unlike the case with patents, copyright protects the expressions and not the ideas. So, in patent it is in idea form, in copyright it is in expression forms. There is no copyright protection for ideas, procedures, methods of operation or mathematical concepts as such. In India, the duration of copyright for authors is the life of authors plus 60 years after his or her death, and for cinematograph films and sound recordings 60 years from the year of production. After the death of the owner, the right passes on to his or her legal heirs. Now, we will discuss about some of the challenges in negotiations on various IPRs under TRIPS for India. Presently, there is some debate on the patenting of life forms, whether access to medicines through Doha Declaration has been achieved. Other issues of concern are biodiversity and its link with sui generis systems of plant protection and technology transfer. There is also debate on whether to extend enhanced protection for geographical indications beyond wines and spirits. Internet access and sharing of electronic files has questioned some of the established rules in copyright. On all these issues, India needs to examine world trends and proactively develop informed policy interventions. So, in this discussion, we have focused on like what India has done so that in conformity with the TRIPS, what are the provisions of Indian Patents Act, Copyrights Act, Designs Act and Trademarks Act. We have also discussed some of the challenges which India presently is facing and where it needs to gear up so that it can meet these challenges and where brainstorming is required. In the subsequent discussion, we will discuss about the different conventions and eligibility criteria. We can also discuss about the, like we have discussed about the Locarno system of classification. So, in one of the discussions, we are going to discuss in details about this, so that this remains as reference point with us, which we can refer to while we are trying to look for the protection of our own IPR. Now, why in engineering practice we are discussing about this? Because while we are looking for engineering designs and like processes of doing things, maybe we will be facing issues of patent, like if you have an idea of developing a design, so where to go for look for patent, how do you if you are an engineering entrepreneur, maybe you want to do something on your own, how to go for the trademark, then what are the issues of copyright in it, how can you protect for your design. These will become important issues when you are going to, maybe as entrepreneurs, you are going to open up your own firm and you are going to look forward to your own inventions and designs and developing new products and services. So, in that aspect, this is a very, very important discussion to the like engineers, engineering entrepreneurs, maybe who are developing products and services and thinking of doing something on their own and want that like they like get the benefit of it also, and also on the other hand share it like with the society and public at large, so that their work gets recognizable. Thank you.